Ms. Connolly, good morning.
Good morning. Good morning, ladies and gentlemen of the court. A misunderstanding of mistaken identity between Mr. Maimaron and then off-duty Trooper Oxner, while both were drinking at Dee Dee's Lounge in the Wollaston section of Quincy, erupted and spilled onto the streets of Quincy in the early morning hours of November 23rd, 1999, leaving Mr. Maimaron lying face down in a pool of his own blood as a result of Oxner banging his head against the pavement, resulting in Mr. Maimaron suffering a broken jaw, a detached palate, requiring 2 surgeries, a wired jaw, and 2 titanium plates being inserted in his face, permanently altering his appearance. And this is a result of a very brutal and criminal assault and battery by Mr. Oxner on Mr. Maimaron, and then subsequently trying to cover this up, and the involvement of Mr. Oxner's friend, and not a police officer, Mr. Roach, by filing a false police report.
Truly, this is a brutal attack. I take it the officer is still on the police force, however?
He was disciplined, and he was suspended for 4 months. He went through a disciplinary proceeding. And he was also charged with assault and battery and filing a false police report criminally. And through a plea bargain with the U.S. Attorney's Office and the Attorney General's Office, he agreed to plead guilty to the criminal assault and battery and filing the false police report in exchange for having the Attorney General and the U.S. Attorney General not seeking any further charges.
And it's quite clear you admit, as you must, I think, and as you have repeatedly in the past, that these events occurred in the course of an arrest, and that he was authorized to make an arrest?
Excuse me, Your Honor. I don't think there was any probable cause for the arrest, and I don't think the record supports that there was probable cause for an arrest.
Yeah, but the question was he authorized to arrest?
It was the type of job, certainly, that he was hired to do, was to make arrests.
And the injuries were incurred in the course of him making an arrest. Whether at the end of the day it lacked probable cause or not, that was his job, to make arrests.
And that is one of the 3 factors under the respondeat superior analysis to determine whether someone's acting within the scope. It is true that the type of job he's hired to perform is to make arrests, but under the Klickner versus City of Lowell, when we get to the next 2 factors, one is, did it occur within the time and space authorization? And 3, was this something that was furthering, in some respect, his employer's interest? I think both fail.
You make an analogy in your brief to a state trooper who is at home and shoots his wife. But isn't there a great difference between that and Oxner, who apparently was trying to make an arrest? Someone at home shooting his wife wouldn't be involved in making an arrest.
Well, Your Honor, 2 points on that. One, the argument, the lower court erred, we believe, on this, and that argument is echoed in my brother's briefs in this case, and that is that this duty to defend under Section 9A of Mass General Laws, Chapter 258, is divorced from whether the intentional acts and civil rights violations arise in the scope of someone's official duties. So that's the first point. And the second point to your question, I believe, is that if the first paragraph of Section 9A is divorced from the second paragraph, meaning that it happens within the scope.
But why should they be divorced? The second paragraph says in this section.
The section meaning all of 9A,
right.
Not just that paragraph.
Right.
So if you, in the example of going home and shooting your wife, if you shoot your wife and your wife then sues you for civil rights violation, under the court's reading, the Superior Court's reading of Section 9A, we'd have to defend for that it's mandatory. There are no exceptions to this defense, that any trooper sued for a civil rights violation or intentional tort would have to be defended. And we think that is contrary to public policy and contrary to the language of Section 9A.
But that's not this case. I don't disagree with you, but that's not this case.
No, but we think that if you look at whether someone is acting in the scope of their employment under these facts, when you have a criminal plea, when you have disciplinary action by the employer who's not ratifying but rather punishing this behavior, that the state police never thought that this was happening within the scope.
They could have punished this behavior. Let's say it was a bank robbery, and he was off duty. He stops the bank robber and pummels him on the ground. He could still be disciplined for that act of pummeling for using excessive force and false arrest.
Yeah, even on a legitimate arrest.
A
Right,
legitimate
but in this
arrest can
case,
trigger a excessive force claim. And I must say, as I understand all the mistakes that occurred as to how this erupted, at the time, Oxner might indeed have legitimately thought he did have probable cause. He had told the man he was a trooper. The man had hit him with mace. That's assault and battery on a police officer. He didn't know or didn't appreciate that Maimaron, whatever his name's pronounced, didn't believe he was a police officer, thought he needed to use his mace in self-defense. Those facts came to light later. At the time, Oxner could have had a good faith belief that he had a solid basis for arresting this man.
But if he did, why did he file a false police report right afterwards, and why at the scene did he
To
lie
cover up
about the
excessive
involvement?
force. Yes, but from
Because
his
I
point
would-
of view, he might have thought, I'm making a legitimate arrest. He then gets carried away and uses excessive force.
And he also lied about the involvement of his friend, Mr. Roach. And if he was supposedly concerned about assaults and batteries on people, why didn't he arrest Mr. Roach for assaulting and battering Mr. Maimaron?
Well,
when
that's
he
a different
tackled
question.
him?
That's a different question, though. Really?
Well, I think it's selective.
Conley,
I think it's.
Can we not observe that there have been cases of people clearly acting within the scope of their responsibility and subsequently filing false reports?
But I
mean,
think
the
that,
fact that somebody filed a false report can't inform whether or not they were acting within the scope.
well, I think it does in this case for this reason, Your Honor.
May I just finish? Except to this extent, if he believed he was acting within the scope, he certainly would want to cover up what he had done.
I think as this court observed in the city of Boston versus the Boston Police Patrolman case in 2005, that there's a very clear and dominant public policy about the integrity of the police force.
There's no question about that, and that really goes to disciplining the officer or what you do with an officer who engages in this kind of conduct.
Yes. And I think
Not to
that
these
when
other
you
issues.
when you file a false police report that results in a null pros of the case, I don't understand how that could then be read to say that you were furthering your employer's interest by filing this report and committing this arrest.
Now,
Now, wait a minute.
I know
No,
you've
wait a
tried to.
minute. No, you can't link the two together by filing this report and committing this arrest.
Well, what I meant to say, Your Honor, is by filing a report to cover up the false arrest, the arrest that you never had probable cause to engage in the first instance.
But, you know, I mean, I know in your, I guess it's your reply brief, you claim that you didn't mean to admit to all of these facts, which it appears to me you have admitted to, which indeed include that Oxner believed that the individual here had committed a crime, believed he was obligated to arrest him, and believed he was on duty for those purposes. Doesn't that end the inquiry right there?
The inquiry as to whether or not he was
Acting within the scope of his duty?
I don't think it ends the inquiry right there. However, I would agree with the court if the court believes that the state police's determination at the time of the case it did in 1998, after the criminal procedures and the disciplinary procedures, that the state police and the Attorney General were premature in denying a defense in this instance, then as the questions here suggest, that it should go back for a full hearing on whether or not he was acting within the scope and whether he was acting in a willful, wanton, or malicious way, and the Commonwealth should not be bound by the arbitration determination in that matter, and that the Superior Court erred when they held that as a penalty for not defending Mr. Oxner, that we are then bound and cannot contest whether he was acting in the scope. That's not within the language of 9A, and in fact, it's contrary to even insurance decisions. And I would cite the Polaroid versus Travelers case.
Ms. Connolly, let me just shift the subject a minute to the second part of this, which is the indemnification question. And I'm curious as to what your view is as to how the state should represent or defend itself when it has a conflicting claim, as it does here, with respect to a police officer. I assume that the state would, if the state did recognize that he should be provided a defense, they would assign somebody, some independent counsel to represent him. But how, in your view, how should the state protect its own claim that the officer was not acting in the scope of his authority. How should that come about?
Well, Your Honor, at the time the Commonwealth was initially a defendant in this case, in addition to Mr. Ochsner, the Commonwealth and other troopers were also defendants. The Commonwealth settled out the supervisory liability claims, and in that settlement and release was carved out the claim that could be brought for indemnification under 9A. The expectation always was that we would all be coming back another day to have that battle. And
was that expectation expressed in any way?
well, it was expressed in the settlement and release agreement. I know that. I don't know what other discussions. I wasn't involved in that. I do think that, like in Pinshaw, the claim is then someone brings a suit against the Commonwealth saying indemnify us. And then we can have this robust litigated debate about whether someone's acting within the scope. I would suggest to the court, though, in this case, Section 9A, I think, has been enacted for 24 years. This is the first instance I'm aware of that the state police at the outset said, we're not going to defend you. In the other cases, as this court knows from the Burke decision recently decided, that the state police pays a certain hourly rate to defense counsel selected by state troopers to defend them in these cases. This is not a frequent occurrence. That there's an important countervailing public policy here about using public dollars to defend what a really rogue conduct by a police officer in this case. That it shouldn't be condoned, and the state should always have the right to contest that. And if we were premature in doing that, we could pay Mr. Ochsner for his legal defense funds expended to date, subject to the right to get it back after we have a determination of whether he was acting in the scope.
At what point are you supposed to decide that, whether he was acting in the scope?
Well, in this instance, it was decided at the outset because of the information available to the state police prior to and commensurate with the civil lawsuit filed by Mr. Maimaron. The criminal plea had already happened with the statement, the disciplinary action had already happened, and then the complaint by Maimaron.
Well, so that's an internal determination, but how does it become a binding determination on the police officer?
Well, Police Officers Council wrote a letter to the Attorney General's office in late 1998 requesting defense, and in early 1999 the Attorney General's office, counsel for the state police wrote back saying for the following reasons, we don't think you were acting in the scope, and also cited to a CMR.
But that's not binding. At some point, some court is going to have to decide he was acting.
And Mr. Ochsner at all times was free to sue us and bring a declaratory judgment and make that and contest the determination that the state police made in this case. There's nothing in 9A that says the state police have to file the DJ action. There's no, as the court in Pinchar has pointed out, there's no administrative procedure under 9A. What I would suggest to the court, if you look at all of 258, in Section 2 it says the public attorney shall determine if someone's acting in the scope. Section 9, Section 9A and Section 13 all require you to be acting within the scope, but don't have similar language.
Okay, so are you saying that there has to be a 30A appeal from that determination?
No, Your Honor. I'm just pointing out that because there's nothing in the statute that requires some procedure, there's nothing incumbent upon the state police to say you have to, the first instance, go file this DJ action. There's no violation of a procedure that's been committed here by the state police in making its determination.
Forgive me for interrupting you, but
Certainly.
But why wouldn't we be inclined, at least to think of this? There's a considerable body of law where there have been private agreements to assume the duty to defend, and one of those is the insurer. In essence, the Commonwealth is the insurer here. Undertakes to represent, but says, I won't represent you if, and it could have been intentional tort or something like that. They make a determination. If they are sure, they just make the determination and let the other person, the insured, here the police officer, sue. If they're a little, they're not quite sure, they may themselves file a declaratory judgment action. And if there is in fact an action by the insured that in fact establishes that it was within the scope of the official duties, the Commonwealth leaves itself open to, having to repay and maybe some other kind of penalties. I don't know what those would be, but...
Your Honor, I think that some of these parameters you're talking about would be useful guidelines for the agencies when dealing with the state police in dealing with this as a going forward basis. In this case, if you find the state police was premature in making this determination, then let us go back. We can indemnify him for his attorney's fees, and let us have that dispute about whether he was acting within the scope.
Sure.
The Polaroid v. Travelers case clearly states, even in the insurance context, that you can't penalize an insurer who doesn't have ultimate indemnity liability if they breach the duty to defend by saying you're automatically on the hook for all indemnity. That's
I
the
think that's
the Polaroid case. And to bind, coercively really, bind the Commonwealth to this arbitration, counsel says it was inexplicable we didn't attend. Well, the Commonwealth had a conflict with Ochsner. We couldn't represent him. He was represented at the arbitration, and the Commonwealth would not have consented on its own behalf to go there. And I don't think, frankly, it would have been helpful for Trooper Ochsner for the Commonwealth to have attended an arbitration to say he wasn't acting in the scope of his duties at this time. Arbitration is a voluntary...
Do you know, is this a common practice, this assignment of rights of the underlying case? Is that done frequently in these type of proceedings?
We're seeing it with, well, in the reported cases, it's been frequent. Pinshaw, for example, there's an assignment of rights as well. And I think that's when the thought is that the trooper doesn't have assets or the official doesn't have assets, and this is the insurance, this is the deep pocket.
Well, what I'm wondering is, do the parties to the arbitration know that this is what is going to happen?
I think if you look at that arbitration finding, it is result-oriented. For example, the arbitrator didn't need to find that Mr. Ochsner was acting within the scope.
No, I understand you made that
et cetera.
argument, but my question is whether it's a sufficiently common practice that the parties here knew that that was the ultimate.
This is the only arbitration I'm aware of in 7.5 years in the Attorney General's office on this matter.
Ms. Connolly, here's the problem which you face, and arbitrators can be asked to make certain findings. They can be asked to make findings.
But how can they be binding on someone who's not a party?
Well,
And never consented to be a party. This would be
and
a
there was
coercive...
no statute or
I'm not
contract.
arguing that. I'm just saying. So whether or not, before an arbitrator, you can ask an arbitrator to make findings. They may or may not be binding. There may have been opportunities I don't know about that. But the fact that there are questions, you may want a very specific question answered.
Well, it is true that as between Mr. Maimaron and Mr. Ochsner, those arbitration findings are binding. But what we would dispute is those findings, as they may apply to the Commonwealth, are not binding.
No, I understand that's your point.
And Your Honor, what we would ask the court to do is vacate the Superior Court's judgment for the plaintiffs here, remand this back to the Superior Court for a trial on the question of whether he was acting in the scope and whether he was acting in a willful, wanton, malicious way. Even the arbitration findings only talk about wanton and malicious. They don't talk about willful. And punitive damages were never asked for in this complaint, so I don't know why the discussion of willful, wanton was involved. I'm sorry, Justice Cordy.
I mean, willful really doesn't mean much more than intentional. And, of course, this whole statute relates to defense in intentional tort cases.
Correct. And the court has held that this willful, wanton, malicious talks about the punitive damage standard. Right. And where no punitive damages were asked for, only compensatory damages in Maimaron's complaint, it's not a material finding of this arbitration that he wasn't acting in a malicious or wanton manner. So remand this back. Let's have a trial on whether he's acting within the scope. If the court finds we were premature in our decision on that, we could indemnify Mr. Ochsner for those fees, subject to the right to get them back if there's an ultimate determination that he was not acting within the scope or he was acting in a willful, wanton, or malicious manner.
Thank you, Ms. Connolly.
Thank you very much.
Mr. Stern?
Max Stern for Mark Maimaron. There are two grounds to affirm the decision that the Commonwealth must pay for the judgment against Mr. Ochsner. The first is based on the Chapter 258, Section 9A, duty to indemnify the judgment, as opposed now, is distinct from the duty to defend Mr. Ochsner or the violation of it.
Let me pursue that point with you. In just assuming, for the sake of discussion, that the Commonwealth had assigned private counsel to defend him, how does the Commonwealth properly protect its claim that the trooper was not acting in the scope of his authority?
What it does is it brings a declaratory judgment action in the Superior Court to absolve itself from any duty.
And it should have done that beforehand.
It should have done that, and this happens all the time in the insurance context, and typically what happens is that declaratory judgment action is resolved before the underlying case is resolved. And if the insurer, and in this case the indemnitor, has a complete opportunity to contest its duty, in this case whether it was within the scope of the employment, and otherwise whether the conduct was so egregious it's beyond the scope of the indemnification, and it can absolve itself of the duty to defend, then it's free to go.
And here, if that had happened and they had been told that yes, you are going to have to indemnify him, I take it, it might have been able to resist arbitration by saying, look, we don't want to participate in the arbitration, but let's proceed to a trial in front of a judge.
Well, if it had taken on the entire defense, it basically has three options in general. It can take on the defense, and therefore it could control the defense, or it can defend under a reservation.
But there's a divergence of interest here.
Yes, or it can defend under a reservation, or it can bring a declaratory judgment action.
I take it, Mr. Stern, among other things, if they bring a declaratory judgment and it's determined that the officer was acting beyond the scope and therefore the Commonwealth won't indemnify, that will tell your client, based on the resources that your client has ascertained the state trooper has, as to whether or not to really litigate this, to the hilt or to settle for some.
Yes, that's true. I mean, they're out of it at that point. At that point, they're out of it completely. They've had their chance to contest. They're out of it. We're now dealing with Mr.
They're either in or out.
Excuse me?
They are either in or out.
That's right. Now,
how can you bind the Commonwealth, or how can you seek to bind the Commonwealth to the arbitrator's findings when they didn't participate?
Because under the law, the very well-settled law of indemnification, when a claim is ostensibly, the word used is ostensibly, within the scope of the indemnification, and the indemnitor is given notice and an opportunity to defend, it is then bound by the material findings in the underlying case.
It would be the same as if the insurance company had the obligation to defend and said, well, we're just not going to go to the trial.
Exactly.
Right?
Or
it did go to the trial.
Or the insurance company said, I don't think I have a duty to defend, but meanwhile this thing is rolling along. You make a business judgment as to whether you recognize you're going to be bound by the outcome. And so if you really want to fight when somebody comes over, I mean, it's not clear who's going to come over. It may be you, meaning the third party that's been injured, suing for indemnification. It might be that you have a state police trooper who happens to be unusually wealthy and can satisfy the judgment, but he wants to be indemnified. And at that stage, the Commonwealth may be able to put up a duty to defend, but it may not put up a duty, it may not challenge the underlying facts.
That's right. That's right. But we have two theories here. One is, under the indemnification law, the indemnitor, having had notice of a claim which is ostensibly within the scope of the indemnification, then that indemnitor is bound by the underlying material findings. And we say the findings here as to scope and as to lack of malice were material to the findings.
The lack of malice material. I understand how the scope was material in the sense of under color of state law. But how is the willful
It's
wanton?
because it's not under color of law if there is a purely private grievance. For example, if the action is taken solely out of a desire for revenge, that's not under color of law.
Right,
In this
I
case,
understand that, but how is the willful wanton?
well, I think it supports the notion that he's not acting out of a purely private desire for some kind of revenge if his intention here is not to hurt, not to injure, but he's really acting in a good faith but erroneous attempt to restrain the person.
Were punitive damages sought in the arbitration proceeding?
No. No, at no point did we seek punitive damages.
Okay, is the willful, wanton, or malicious necessary is it in the statute to identify the state's responsibility for punitive damages, a finding of punitive damages?
Well, what it says is willful, wanton, or malicious, and the Pinshaw court construed that to mean the punitive damages standard.
So the arbitrator essentially found, by making that finding, even though it wasn't an issue in the case, the arbitrator said, you're not entitled to punitive damages, is really all that means.
Well, that's true. And as far as materiality goes, I think the Commonwealth is at great length about saying how this finding is not essential, positing this as an issue of collateral estoppel. The issue here is materiality, and materiality traditionally means having some tendency to affect the decision maker.
Yeah.
And I think it is material in that sense.
But let me play it out a different way. Supposing the arbitrator had said that you were willful, wanton, or malicious, and I'm going to award punitive damages, doesn't this whole thing only mean that the state would not have been responsible for those punitive damages?
No. Well, yes, it wouldn't have been, because there would not have been any award of punitive damages. Yeah. Frankly, if the arbitrator had made an award against us on that, I'm not sure we would be bound, because we're not the indemnitor.
Yeah.
So we probably could have gone forward. Commonwealth would have had a nice argument, and there would be some persuasive force to it, but I don't think we would be bound by that particular adverse finding. But it didn't happen that way anyway. But now let me turn to the duty to defend, which is a separate ground than the duty to indemnify. The duty to defend exists as long as there is any possibility of a judgment within the scope of the indemnification, and the Commonwealth clearly violated that in this case. Now, I agree with the Commonwealth that that violation, that itself, as opposed to the indemnification issue, that doesn't get us all the way home. Under the Polaroid case, sure. What that does is it shifts the burden of proof. Now the Commonwealth has the burden of proving that we're not entitled, or that Mr. Ochsner is not entitled to indemnification. But as Justice Cordy noted, on summary judgment, the Commonwealth admitted basically all of the material facts here about within the scope, that he believed Maimaron had committed a crime, that he was trying to make an arrest, that he was trying to restrain him, and so on and so forth. And I should add, not only did they admit things, but they didn't offer any facts to the contrary.
Did they admit the willful, wanton, malicious part?
Well, they admitted I would say the operative facts, that this was an attempt to restrain Mr. Maimaron, who we thought was trying to get off the ground. The one fact that they argued on that point was that they cited the fact that from our original complaint, where we had originally alleged that Mr. Ochsner had repeatedly slammed Mr. Ochsner's face to the ground, and that on its face of the complaint was not based on anything that our client perceived, because our client was unconscious. It was taken from the comment of a bystander by the name of Fennessy. This is alleged in the complaint, somebody who was not to be found by the time this case came to be litigated. So there never was any evidence. When the evidence came out, it was clear that this had not happened, that he had not done that he had not kicked him, that turned out was his friend, Mr. Ochsner's friend, had kicked the can of mace away.
Well, how did it get into the case? Was it in a police report?
Yes, there was. Mr. Fennessy had spoken to some officer.
And where was that introduced? Was that introduced at the arbitration?
No, it wasn't. But it was. It wouldn't have been the report itself.
We have a missing witness who might well be able to demonstrate that this was wanton, willful, and malicious. But neither side can find that witness these days.
That's right. I don't know where he is. Now, there is another reason why.
Well, did either side have an incentive?
Excuse me?
That's the problem with this whole case. Neither side might have had an incentive to find him.
Well,
that's the trouble with the whole case, that the two people are
well,
more or less on the same side.
We had, yes, but the Commonwealth was invited, and it's not just that they were invited to come and defend. They were invited to come and attend. They could have been there. The suggestions that there was that we cooked this sort of thing are really, I think, are really offensive. If we were trying to collude here we certainly would have done a lot better than $363,000.
And I take it that claim was not made below.
No, it was not.
Say that again.
Now, there's another reason why the Commonwealth cannot validly contend that these actions were not willful, wanton, and malicious, and I think that's the greatest irony in this case, and it's something that was touched on by Justice Cordy before. When the issue of Mr. Ochsner's continued employment came up in a disciplinary proceeding, despite his conviction for assault, the Commonwealth, through its appointing authority, relied on certain mitigating circumstances, to wit, Ochsner's belief that Maimaron committed a crime, the fact that his use of force was in a good faith, if erroneous, attempt to restrain Mr. Ochsner, Mr. Maimaron, that there was no desire to hurt Mr. Maimaron. And it relied on these factors to make the determination that Mr. Ochsner should be able to continue to exercise his police powers, which he does to this day. But when it comes to the victim here, and of course under the Pinshaw decision says, look, the major purpose of this statute is to compensate people who are the victims of these civil rights violations. When it comes to the victim here, who goes the rest of his life with a metal plate in his head, now they say, well, we're going to forget about those. And now we're going to say we don't believe now, lately, when we get to the reply brief in the appeals court, we're going to say we don't believe a word that Mr. Ochsner says, and his actions were so vile and egregious, they're beyond the pale, and we're not going to indemnify him. I suggest to the court that those positions are totally, utterly irreconcilable, and in this respect, the Commonwealth is bound by the principle of collateral estoppel, issue preclusion, which applies to findings made in an administrative proceeding, and they're precluded from taking that contrary position now.
Thank you,
Thank
Mr.
you.
Stone. Mr. Glody.
Good afternoon. My name is Rick Brody, and I represent Mr. Ochsner. Initially, I'd just like to say one thing, and that is I was involved in this case almost from the get-go. I asked time and time and time again that Mr. Ochsner be given a defense by the Commonwealth pursuant to the statutory scheme. If you look at the record appendix, I sent letter after letter after letter setting forth both Philippone, Pinshaw, and what I had thought this court had made clear that the insurance model was one to look at when one decides whether or not to represent a police officer where there might be a conflict with the Commonwealth.
But it's clear that the Commonwealth does not have a duty to defend if, in fact, your client acted outside the scope of his duties.
Okay. If, in fact, he did, that's
right.
correct.
Or engaged in willful
Unfortunately, they took the leap. They took, well, as my brother just told you, it's settled law. Take a look at the complaint. From the four corners of the complaint, is there any way that you can make a determination that this could be within the scope? The complaint said it was in the scope. It said, if you read the complaint, he used his police powers. He showed his badge. He told them he was a police officer. He asked for assistance as he ran through Quincy. And I understand why his sister has her own position. And I understand that this appears at first glance to be a brutal attack. And that's the way they bought it. And that's what they kept saying through the next 7 years. They never looked at the facts. If you take a look at the facts, and that is the deposition of Mr. Maimaron, the deposition of Mr. Ochsner, the independent witnesses who I had access to, it was no doubt that this was an unfortunate and ultimately a terrible thing that happened to Mr. Maimaron, but it was understandable from Mr. Ochsner's point of view as a police officer. He told Mr. Maimaron he was a police officer. Maimaron kept bothering him in the bar. Maimaron had between 10 and 12 beers that night.
Is there any evidence he told Ochsner he told Maimaron in the bar that he was a police officer?
Mr. Ochsner was with his wife. Mr. Maimaron came over to him. He had a couple of pops, and he says, "I know you. You're so-and-so." He says, "No, you're wrong." He says, "I know you." He says, "No, you're wrong." And he said, "What do you do?" "I work for the state." He didn't want to get, and he said, "What do you do for the state?" "I'm a state police officer." "Yeah, who do you know?" And then he started going through who he knew as a police officer. There were people around who heard that, who were willing to testify to that. Finally, he said, "Look, just leave me alone." Then, something my sister left out in her brief, and that comes forward in the depositions, Mr. Oxner went to the men's room. Shortly thereafter, Maimaron follows him into the men's room. Now, it may have been very innocent. Maybe Mr. Maimaron had to go to the bathroom. But Oxner believed he had followed him in. And he had no idea what this guy was doing, except he was acting very weird. He comes back out, tells his wife, let's get out of here. They start to leave, and again, temporally, it's a coincidence. Maimaron leaves at the same time and walks by he and his wife as they're about to get into the car, and Mr. Oxner is apprehensive. Who is this guy? What does he want from me? And he says, hey, you wanted my identification. Let me see some identification from you. And he said, and the expletive is said. Oxner says, wait a minute, and he grabs him by the shoulder, at which time Maimaron turns around and sprays him with pepper gas.
Mr. Brody,
what is he going to do?
You're rehearsing the facts now, and we're trying to
No, I
get the legal
understand.
issues
The
sorted
only reason
out,
I
and
say
your
this,
time
and
is
I
up.
apologize, it's just that I've been living with this forever, and Mr. Oxner became not just my client, but also someone I felt sorry for and I respected. And I just want the court to know that, yes, it was brutal, yes, it was awful, but it was understandable. And they had an obligation, as soon as they saw the complaint, to do one of a number of things under the insurance model. They could either file a DJ, they could have said, okay, we will defend you, and but it's a reservation. Do you want us to appoint someone, or do you want someone to appoint us, to have appointed? Or three, they could have done it under a reservation, and he could have gotten his own person. It's clear law. I mean, it is beyond me how they walked away from this.
Thank you, Mr. Brody.
All right.